Terima kasih saya ucapkan kepada saudara pengerusi majlis. Sorry. About 20 years ago, Dr. Mahathir Mohamad was Prime Minister of Malaysia, and during that time many things happened which resulted in many of us declaring then that democracy is dead. Today things have reached such a level that Mahathir himself is saying that democracy is dead. Well, I guess when my good friend Shah reads out from Lord of the Rings, and as I said to you, with Mahathir lurking around, complaining that things are wrong, I think things are seriously in need of a checkup in this country. Ladies and gentlemen, this can be a very dry topic if one doesn't look beyond the words of the statute that we are dealing with. Now let me get straight to it. Dan saya berojokkan kepada section yang berkaitan, which is section 124B of the Penal Code. Shah read it earlier, but I think it needs to be read again, because we should not just look at 124B, but we should also look at the other sections which follow, which will give you an indication of how it is things can go wrong if this section is open to abuse. Now, section 124B reads as follows: activity detrimental to parliamentary democracy. Whoever, by any means, it covers anything, directly or indirectly. So it's not enough to say by any means, but they must make it even broader by saying that directly or indirectly commits an activity. Activity includes almost anything. So you've got any means, directly, indirectly, commits an activity which includes anything, right? Commits an activity detrimental to parliamentary democracy shall be punished with imprisonment for a term which may extend to 20 years. Now, you can see that it is broad, it is open to wide interpretation, which may lead to abuse. And of course, I think more importantly, it carries a very, very, very severe penalty. So of course, the question which arises is, what do you mean by parliamentary democracy? Now of course, in this statute, we have 130. Shah read it. I'll read it again. Activity detrimental to parliamentary democracy, a very long word, means an activity carried out by a person or group of persons designed to overthrow or undermine parliamentary democracy by violent or unconstitutional means. It really doesn't say anything actually, it's just a long phrase which really makes it even more confusing. So this is the problem that we have. Now if you look at 124B and what I've just told you, of course we get alarmed. We think, in a country where there has been abuse of laws and there is a government which wants to stay on in power, then this kind of a provision can be put to serious abuse. Then we look beyond 124B. You have 124C. So 124B was in respect of activity detrimental to parliamentary democracy, and I said to you, very broad. And just in case what you do doesn't come within that, I mean it's so broad already, but never mind. In case there's something that doesn't come into that, you got 124C, which is an attempt to commit activity detrimental to parliamentary democracy. So don't worry, it's all broad, and if you get away with that, even if you attempt, it's an offense. And they make it seem nicer, it's not 20 years, it's only 15. It doesn't stop there. Then it goes on. So you got activity detrimental to parliamentary democracy. Then you got an attempt to commit that activity. Then you got printing or sale of documents and publications detrimental to parliamentary democracy. Whoever by any means, directly or indirectly, prints, publicizes, sells, issues, circulates, or reproduces any document or publication detrimental to parliamentary democracy shall be punished with imprisonment which will extend to 15 years. Just printing, whether directly or indirectly, or by any means, or circulates, reproduces any document, and you are liable to be convicted for an offense. It goes on. If you don't print it, if you don't circulate it, don't worry. Possession of it is enough to commit an offense as well. That's 124E. Possession of documents and publication detrimental to parliamentary democracy. Then it goes on. It doesn't stop, It goes on. Well, when Nazari is minister in Prime Minister's department, what can you expect? Importation of document and publication detrimental to parliamentary democracy. Posting of placards. Any person who posts or distributes any placard, circular or other document containing any incitement, violence, so forth, disobedience to the law, likely to lead to breach of peace, shall be punished with imprisonment 5 years. And I think in respect of that provision, dissemination information is connected to the publication and circulation, as I said earlier, of material that is considered activity detrimental to parliamentary democracy. So what do we have? You have a press conference, for example. In the press conference, a group of people say certain things about a meeting of persons. That becomes the basis for an arrest and investigation for an offense under this section. Recently, activists at Adam Madli and that group, Mandip is here somewhere, the Mandip is there. I told Mandip just now, I said, stay out of the orange suits if possible. Because that's what he came to court. Was it purple? Orange. So you have a press conference in which you declare your stand in respect of a certain gathering that's considered activity detrimental to parliamentary democracy. A press conference. Now if you talk about anything which relates to that press conference, it is also an activity detrimental to parliamentary democracy. There is essentially nothing you can do which does not come within the definition of this section. And even if you don't do anything, if you are in possession of something, that is an offense as well. Now let us get back to the practical realities of it, and the reason why I think that this is something that needs discussion. First, when we deal with offenses, a police report is lodged, and that is sufficient for an arrest to be made. And of course, if an arrest is made, the police will apply for remand. Ordinarily, from what we see in the last few cases, you have remand applications. They ask for 7 days. In other words, they put you in a lockup, you are handcuffed and so forth. They ask for 7 days. And with great respect to the police, in the last few applications that I have appeared in, they need time for chap jari, which is take your fingerprints. They need time to take your photographs. They need time to take a statement, and they need time to basically figure out what's going on. Right? They want to get more information about who is involved and so forth. This is clear abuse. Now this is just for remand. Now assuming after investigations a charge is laid, you go to court and you are there before a judge, and the judge says to the prosecutor, what does activity detrimental to parliamentary democracy mean? the public prosecutor will stand up and say, look, as far as I'm concerned, this is what I think it means. I think it means anything that is done which puts a ruling government in an obscure position. Because that's what it is. So in other words, if Prof. Aziz Bari were to stand up and say that he is not happy with the government of Malaysia, they can pen out a case under section 124B. We have got Dato' Ambiga, who's also been held up, 124B, Tony Pua, politicians, members of parliament. Now, in the past, we have had laws like the ISA. Now, why were we geared against the ISA? Why was there this entire effort nationwide, worldwide, to get rid of laws which allow for detention without trial? It was simply because of how it is those laws were abused. In other words, where laws are made and those laws give ultimate power to a particular person, they can be abused, and when they are abused, of course, that becomes basis for us to raise objections. Of course, we fought that. And of course, Najib comes in, he says, I'm going to make Malaysia the best democracy in the world, which he's slowly making, as you can all see. And he removes the ISA. So what happens is he's taken out these powers of detention from the minister. It's now gone before Lembaga and the POCA and so forth. But that power is taken away. And when it is taken away, we say that it's a victory for us, because now civil society, NGOs, politicians, academicians, Malaysians can speak without fear of favor, and they can say what they think needs to be said in order to correct our government so that we can make Malaysia a better place. That is what we want. But unfortunately, whilst they remove laws like the ISA, which bring pressure to bear on the likes of us, now we have statutory provisions, which means it doesn't go through the ministers anymore, but it goes to court. The police are given powers by which they can arrest, or they can threaten you with arrest. And at the end of the day, you go to court, and there is this whole broad interpretation which you and I really don't know whether will fit in to the case that is made out against us. So that is where we are now. And if we look at what is happening, let's look at the case at hand. We've got a prime minister who has got a lot on his hands. Allegations made against him. Now, circumstances like this have led to various calls by politicians, NGOs, civil society, as I've said. The general feeling of Malaysians is that now is the time to speak up. Now is the time to question the government. Now is the time to ask questions which matter to us. To ask our Prime Minister to explain what it is happening. Ask him to tell us. Answer those questions that he needs to answer. But when these questions are asked, there are arrests made. You've got the Sarawak report, which has been shut down. As I said earlier, the Edge. You've got politicians who have taken up the point being stopped from leaving the country because there is an investigation pending. So the question is this what this statute was made for? Now let me tell you this. In Parliament, when this was debated, Dato' Sri Nazri said this. I'm going to read it to you in Bahasa Malaysia. Now he says this. Tuan Yang di-Pertua, jika diperhatikan kesalahan di bawah bab 6 menyentuh kesalahan menjejaskan demokrasi berparlimen. Ungkapan demokrasi berparlimen atau dengan izin parliamentary demokrasi telah pun digunapakai dalam Undang-Undang United Kingdom, yaitu Security Service Act 1989. Subsection 1/2 Security Services Act 1989, the United Kingdom memperuntukkan dengan izin, the function of the service shall be the protection of national security, and in particular its protection against threats from espionage, terrorism and sabotage from the activities of agents of foreign power, and from action intended to overthrow or undermine parliamentary democracy by political, industrial or violent means. Oleh yang demikian, ungkapan detrimental to parliamentary democracy bukan merupakan satu ungkapan yang digunakan bagi menghukum kesalahan politik. Sebaliknya, ungkapan tersebut telah dipilih kerana ia merupakan ungkapan tersebut ia merupakan ungkapan yang amat menyeluruh yang merangkumi semua aspek demokrasi berparlimen. Demokrasi parlimen mempunyai maksud yang luas, even he concedes. Perkataan demokrasi itu sendiri membawa maksud pemerintahan oleh rakyat atau wakil yang dipilih dalam pilihan rakyat. Then he goes on to give us an assurance. Manakala demokrasi berparlimen merupakan pemerintahan demokrasi yang dijalankan secara perwakilan. Untuk makluman Dewan yang mulia ini, ahli-ahli yang berhormat, semua yang berada dalam Dewan inilah yang memberi roh dan nafas kepada demokrasi parlimen di Malaysia. So he's saying to all of us that, look, demokrasi berparlimen, it's all here now in the Dewan together with you, my fellow members of parliament. Jika demokrasi berparlimen digulingkan atau dilemahkan dengan cara yang ganas atau tidak berlandaskan perlembagaan, kerajaan akan dibentuk tidak lagi merupakan kerajaan yang dipilih melalui peti undi. So what do we have here? We have a clear declaration by the minister in parliament at that point of time. Number one, it will not be used for political purposes. Number two, it will be used to strengthen the parliamentary institution in this country. In other words, it will actually be used to protect members of parliament so that they can do their jobs as members of parliament, which includes criticizing the government for wrongs that they have done and demanding them to give answers for questions that have been raised against them. That is what happened in parliament. But what we see is when members of parliament ask questions, when we demand the Prime Minister answer, investigation papers or IPs are open under section 124B. Ladies and gentlemen, it is said that penal laws exist in order to battle crime. Broad and wide penal provisions are often said to exist so that they will give the courts ample space so that they can actually deal with crimes in the way that they should. But what of situations where statutes are drafted in such broad ways that they actually allow for persecution? Now we know that Malaysia is currently facing a crisis of sorts. You have obvious scenarios whereby the police are detaining members from the MACC, officers from the MACC. They are also hauled up under section 124B. Even they. So they are investigating claims that we have raised, concerns that we have raised, and while they do that, the police pick them up and investigate them. Now of course the IGP comes up and says, "No, tidak apa, kita hanya nak tanya soalan. Kita hanya nak check komputer saja. When a police report is lodged, we take action." I've got hundreds of police reports lodged by many people which no action has been taken. I think all of us know that. But this is the kind of answers that we get from the IGP. So what does that tell us? That tells us that we have a scenario whereby they will use 124B in a manner in which it has an effect on institutions in this country. You cannot rule that out. It's happening. Whether we choose to say it exists or not is something else. It's happening before us. So the question is this: if you are going to have powers that will allow you to haul up investigators who are looking into problems like this, then do you think this is what section 124B was made for? Do you think this is what Nazri meant when he came to parliament and he convinced members of parliament that this law exists to strengthen the parliamentary or democratic process? I don't think so. And I think this is where we have to look back to the Constitution. We have a Constitution, a written Constitution. We have guarantees. Articles 5, 8, we have Article 10, freedom of expression and so forth. And I think we should look back to the strength that the Constitution gives us. Is Section 124B an affront to us Malaysians? Is Section 124B an affront now to investigative institutions that exist? Can Section 124B now become even a threat to even judges, for example, who carry out their duties as judges? Those are the questions which remain. And I think when you talk about all those questions, we come back to perhaps the most critical institution in this country, which is actually the judiciary. Now, if we have a judiciary that's strong, then of course definitions could be put on Section 124 to limit it and to narrow it down. But that is yet to be seen. In fact, in Mandip's case last week, we attempted, me and Surendran, we attempted to get the High Court judge to actually narrow it down, to tell us whether or not holding a press conference came within the ambit of 124. Because it was his argument, Surendran's argument, that if it did not come within the ambit of 124, then remand for the purposes of investigations under that charge in itself was wrong. But the learned judge did not actually deal with that. He went on to deal with the time of detention and he shortened it. So we did not get an answer from court. I think that the courts must come up, that we must decide, and I think there must be limitations put into place. We must remember the spirit in which 124B was actually enacted. Now, ladies and gentlemen, that leaves us with the question that we all came here tonight with in our minds, which is Section 124B an affront to parliamentary democracy? Is Section 124B an affront to the Federal Constitution? Thank you very much.